Hello everybody, you have tuned in to Irikoze on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Okay, so we have a response from Zellner to the state's response. This reply is, wow. I'll tell you what, I have to split it up into two videos. I'm going to do this first video here, basically covering most of the first half of it, where she's basically picking apart the state's response, showing what they misrepresented, showing what they didn't even address, a few different things that they just failed to even address or acknowledge, and just some interesting stuff here. And then the next video is going to be about how this evidence is, relevant, why it meets Brady, and all those sort of things. So that'll be the second video. But this one's very interesting because, man, she just goes through picking the state apart. And the case law. I had to put on my shirt and tie because the case law that's getting cited here, I mean, it's very interesting. It's, some of it, well, most of it is all from the Supreme Court. There's she's citing the U.S. Supreme Court and the Wisconsin Supreme Court a lot in this. With cases that support what she's saying. It's very interesting, folks. So we'll jump on in. And also like to say, tip my hat to Barb. Barb filed an affidavit with Zellner that shows us exactly where Dietering's head is. It tells us exactly what I thought about these investigators all along, and it confirms everything that I thought about them all along. I'm very happy that she came forward and gave this affidavit. I think it was brave of her, and I commend her. And you guys will see what I'm talking about coming up here, because in my opinion, it really does put the cherry on top of the investigator, the type of investigator that Dietering is. So we'll go on ahead and move on into the first document now. All right, so we are looking at Zellner's reply to the state regarding the CD, the Brady violation. This is a part that at the beginning here, that I found particularly interesting, so I thought I'd share it. The state accepts no blame. This is Zellner talking, of course. The state accepts no blame for these transgressions and invites this court to find trial defense counsel at fault for failing to realize that they had been duped by the state into not hiring experts to perform the same forensic analysis that had been withheld from them by the state. To impose such a crushing burden on trial defense counsel would be unprecedented, unworkable, and unfair at every level. No court has ever interpreted reasonable diligence for trial defense counsel so unreasonably. So, I don't disagree with her. I think it was ridiculous that the prosecution handed it over with 3 weeks to spare, and trying to fly it under the radar, but trying to have the appearance that they were being that they were being fair, and they were treating fairly with the defense. No, absolutely not. There's nothing fair about this at all. Whether or not the judges and the legal system allows them to get away with this is another fact, or it's another issue, but there's certainly nothing fair about it. All right, so now we're going to move into, basically the affidavit from Barb. But I want to say this, because it's regarding John Dietering, Investigator Dietering, who is the lead investigator on the new, was the new investigator, lead investigator on the new case. So we don't know if it's still going or not yet. The motion to compel we'll find out if there's more, if Zellner succeeds on her motion to compel, which is separate from this CD and Brady thing. So, I know it's hard to keep all these different little things straight, but try to remember the motion to compel is different. That's to compel the state to produce their new documents, their new investigation reports. So that's why that is important. And then the CD and the Brady thing is a different motion. So I know it's difficult to keep these things straight. And don't forget that while all this is going on, Steve's original appeal is still happening. It's just on hold or whatever, but it's still with the Court of Appeals. The original appealing Judge Sukowitz and her denial of Zellner's original petition for post-conviction relief. That whole thing getting denied, that is still on appeal with the Court of Appeals. But so it's tricky. It's got, this Court of Appeals has sent this back because of the Brady thing. Then as that was happening, Zellner found out about this. Somebody filed an Freedom of Information Act request, basically, and produced those 60 pages that we saw of case. So there may be more. So that's what the whole motion to compel thing is. So I know it's hard to keep all these things, whatever. But that's what it is. So that's where we're at. And but this part here, like I said, we've got in this new investigation, we've got Dietering going to Mike Halbach, the brother of the victim, having him dig through all of his old computers, desperately looking for, evidence or proof of the damage to the front driver's blinker on the RAV4. So he has gone to the victim's brother and has put this burden on him to help them. Because you know why? Seriously, the only reason that they would actually do that, the victim's family, the only reason they would burden them is if they really truly don't have any proof that damage existed prior to October 31st. The only reason I can imagine that, because you don't just lightly go and start bothering the victim's family like that. So the fact that they got him digging, the way that Josh Redant acted, he had his lawyer there, and he was making sure that they went through it line by line when they were done, because they didn't want anything he didn't want anything he said to have been misrepresented. What does this tell you, folks? This tells you that Josh Redant has not had a very pleasant discourse with investigators in the past. And that's why he's got his lawyer there, and he's checking all the P's and Q's, and he's making sure. He's dotting all the I's and crossing all the T's. So what does that tell you? Then we got Brian Dassey, who is reluctant to let the investigators in. Tells them so. Tells them he's not comfortable with them. But, and kudos to you, Brian. Seriously, I am so happy that you did let them in. You were brave enough, and you sat there and you stood your ground, and you even got in a couple of good comments that I think were awesome. So thank you for that, Brian. But the fact of the matter is that these investigators are walking around and walking into situations where people that, well, obviously Brian's a Dassey, but Josh Redant's not an Avery or Dassey or anything, right? Completely unconnected from the families, and he clearly felt that something was wrong. And don't forget about the one guy who had his friend call from a blocked number to tell John Dietering to stop coming to his house and trying to call him. Yeah, don't forget about that guy. Yeah, that was another interesting one. Look at the way that this investigation has gone. In the reports that we've seen, I don't think this is the way they expected it to go or wanted it to go. So when you take all that into effect, you know that they're feeling weak right now. Like the only thing standing between them and the embarrassment that is coming is the fact that Judge Sukowicz is denying Kathleen Zellner. Okay? Which I don't know that that's going to last. I think eventually on appeal here, something's going to pop. And eventually it's going to be undeniable, and it's going to have to all get hashed out. Because there's a lot of stuff here that needs to be hashed out and argued out in court by lawyers, by people who are going to, go through the veracity of it all. Okay? So that's what needs to happen here, and it's just a matter of when is that going to happen? Hopefully sooner rather than later. But anyways, we'll move into this bit right now where Barb's basically, letting everybody know exactly the kind of guy that John Dietering is. Oh, wow. So this one's a whopper, folks. So there's a few things here. Number one, it explains what Kathleen Zellner is trying to, what is she subpoenaing, what she is issuing a subpoena for, which is the computer tower. And this is very interesting. On August 2nd of 2018, current post-conviction counsel obtained an affidavit from Barb, attached and incorporated Exhibit C, the mother of Brian, Bobby Blaine, and Brendan Dassey. In that affidavit, Barb states, "I distinctly remember at the time I turned over the computer tower to the investigators saying, I am thinking of getting rid of this computer. After I made that comment, Investigator Dietering replied, that would be a good idea, and you should not give that computer to Kathleen Zellner. Well, that sounds like a fair investigator there. That's, basically only give the state stuff. Don't give anything to anybody else because, unbelievable. I can't believe he said that. And good for you, Barb, for letting everybody know that he said that. Freaking awesome. The fact that Investigator John Dietering told Barb that it would be a good idea to get rid of the computer and to not give it to Kathleen Zellner conclusively demonstrates that the computer contains additional relevant and significant information about Miss Halbach's murder. In light of the potential risk that the computer might be destroyed, current post-conviction counsel is requesting that this court issue a subpoena to Barb for the computer. So, Kathleen Zellner is basically now wanting to look at that computer herself. And why not? The state took it back again. She wants to get on there and see what they were looking at. Clearly, you can't trust the state to hand things over in a straightforward manner. So, she wants to get the ball rolling now. Let me get that thing now so I can start getting the whatever's there now. I don't want to wait until 3 weeks before we're about to have a hearing for the state to hand over bits and pieces of it, hidden in mountains of paperwork all over the place, right? Unbelievable. But wow, John Dietering, very, very, just bad form there, dude. I'm sure you didn't want that to get out. Okay, so you see there, bravo, Barb. Seriously, if you hadn't have stepped forward, that information would have just never been known. I've always been wanting that about these investigators, that's clear, bias, clear bias, even to this day. Which I find troubling, and like I said, it could have easily gone unnoticed, but Barb filed an affidavit and made sure everybody knows about it, and that was, you can't help but wonder what they found on it, because if they want to keep it away from Zellner, then look, Zellner's first petition for post-conviction relief got them to initiate an investigation. Yeah, trust me, if she gets hold of that computer, they're going to be filling their Pampers. They're going to be filling their Pampers big time. So anyways, now we're going to move into a bit where we start citing some case law. This part's going to be in regards to the state's claim that Zellner's asking for a evidentiary hearing and stuff is invalid because the evidence that she's talking about isn't exculpatory. So here's Zellner's basic response to that with case law, Wisconsin Supreme Court, and United States Supreme Court case law that says different, that says otherwise. So here we go. So here's Zellner citing a little case law that y'all might find interesting. The Wisconsin Supreme Court in Harris stated, "We agree with Harris that here the undisclosed information is favorable to the accused because it casts doubt on the credibility of the state's primary witnesses." As Harris illustrates, favorable evidence includes impeachment evidence, and the failure to disclose impeachment evidence has been uniformly recognized as a Brady violation by the United States Supreme Court in Weary v. Kane. Now, the interesting thing here and why she's bringing this up is because the state is claiming that you can only have a Brady violation with exculpatory evidence, and that's why Zellner's claims are invalid. And here's Zellner putting the case law right there, where you see the Wisconsin Supreme Court itself in Harris stated that we agree with Harris here, that the undisclosed information is favorable to the accused and it casts doubt on the credibility of the state. So that's impeachment evidence, not exculpatory evidence. So that's the interesting thing here, folks. Citing the Wisconsin Supreme Court itself, I think, is powerful. I think that's going to hold some weight. Okay, so some interesting case law cited, Wisconsin Supreme Court and United States Supreme Court case law. So Hard to argue with, but we'll see, obviously, what happens. Now, we're going to move into the next bit. And the next bit's going to be basically going over all of the trickery used by the state in terms of these DVDs, the CD, the Fassbender report, all of it. So this next bit is basically going to be going through all of those issues, and basically all the trickery that the state was using. So here we go. Oh, this is some pretty interesting stuff here, really, I gotta say. So most significantly, the state completely ignores Mr. Avery's argument that the Fassbender report deliberately misled trial defense counsel into thinking that the computer belonged exclusively to Brendan. No justification is provided in the state's response for this blatant mischaracterization because there is none. Not a shred of forensic evidence ever confirmed that the computer belonged exclusively to Brendan. Mr. Avery has demonstrated, through his forensic computer expert's analysis of the computer data, that Brendan was eliminated from all but a fraction of the searches performed before his arrest on March 1st, 2006. Mr. Avery was eliminated from an even larger percentage of the searches than Brendan. Of course, the state completely ignores the undisputed fact that its own crime scene video filmed on November 12th, 2005, shows the computer located in Bobby's bedroom, not Brendan's. The state simply concocts a specious argument against Mr. Buting and Mr. Strang, claiming neither Mr. Strang nor Mr. Buting requested additional information about the VLCD. The United States Supreme Court has specifically rejected the hide-and-seek standard of reasonable diligence for defense counsel in detecting the intentional suppression by the state of Brady evidence in Banks versus Dretke. The Supreme Court held, a rule thus declaring prosecutor may hide, defendant must seek, is not tenable in a system constitutionally bound to accord defendants due process. That's from the United States Supreme Court, folks. So, significantly, the state ignores that pretrial defense counsel made two specific requests pursuant to Section 971.23. For all exculpatory evidence and or information within the possession, knowledge, or control of the state which would tend to negate the guilt of the defendant, or which would tend to affect the weight or the credibility of evidence used against the defendant, including any inconsistent statements. A second request was made by the trial defense counsel for Brady material immediately before trial on January 18th of 2007. The state makes the unprecedented argument that trial defense counsel should have made a third discovery request for the CD, despite being misled by Fassbender report as to the content and the identity of the primary user of the Dassey computer. So she's just going right after it, folks. Zellner is not pulling any punches, and the case law here is very impressive to me. Obviously, I'm sure the state of Wisconsin will feel differently, but I mean, everything about this stinks. You can totally tell the state was trying to hide this stuff, fly it under the radar, have the appearance of being straightforward and all that, but it's not. It's really not. They were totally playing a rigged game here, and Zellner is really taking it to him. I hope Judge Suk really sits down and pays attention in this case. Okay, so you've all been hearing me go off the rails essentially about the fact that Jerry and Dean were just not given enough time to review this. And they weren't given the things that would have let them know that there was something there. And so, anyway, so you know how I've been just like furious at that. Well, she addresses that bit now, from a legal standpoint as a lawyer. So, here we go. Okay, this basically talks about how late the state turned over the DVDs and Zellner's arguments as to why it is still a Brady violation. So the state ignores Mr. Avery's argument that Brady requires the timely disclosure of evidence within a reasonable time before trial to allow for its effective use. State versus Harris. Hey, there's that State versus Harris again that went all the way to the Wisconsin Supreme Court. That's interesting. The state contends that because Mr. Avery had the 7 DVDs 7 weeks prior to trial, there is no Brady violation. the state ignores the fact that there was not time for trial defense counsel to effectively use the contents of the 7 DVDs in its pretrial Denny motion, State versus Denny. The state in Harris argued that the undisclosed evidence was not material because it did not meet the Polizano test. The Harris court stated that we find this argument to not be persuasive because the state never afforded Harris the opportunity to bring a Polizano motion in the first place. The Polizano thing is basically just their way of deciding whether or not something actually meets Denny. I guess it's another way of saying it, that whether or not something meets Denny or meets the third party, liability standard or whatever, right? So what it's saying here is that with Harris, the state didn't even really give Harris a chance to have the information to be able to make an effective motion for a third party liability or a motion basically a motion like what Stephen would have made if he had the computer evidence, if they had known what was there. So what the Supreme Court has said is basically that if you don't turn it over in a timely manner to where they actually have the time to go over it, because you have to imagine what's happening. They all have dates that things are due by, so they were already making their Denny motions, and they had no idea that these DVDs were there. They were misled by it. They were misled to believe it was Brendan's computer. There's all kinds of things that they're misled to believe, and so the argument here is with Harris is that Harris wasn't given the chance to pass the Polizano test, and that's going to be a similar situation with Stephen here, where he wasn't allowed to even try the Polizano test. So anyways, Dean and Jerry might have been able to get past this Polizano test had they had the information in a timely fashion, and that's what the Wisconsin Supreme Court is basically saying here in the State versus Harris, that he wasn't given the opportunity, and that's a very similar situation as to what happened to Stephen here. So in Harris, the court explained further that by failing to disclose the suppressed evidence, the state denied Harris the opportunity to further investigate BMM's allegations and bring a Polizano motion. In the instant case, Mr. Avery was deprived of the opportunity to further investigate and develop evidence against Bobby as a third-party Denny suspect. Mr. Buting explained that as of December 14, 2006, a massive discovery was received by trial defense counsel right before Christmas. Don't tell me that this isn't on purpose, and don't tell me that it's fair, and don't tell me that it's above board. Okay? Sending over the hugest pack of discovery, and I'm sure they had most of it for 8 months, and playing things the way that they played it here, dirty. Nothing about it is clean. Everything the state does in the Avery case is just dirty. So, the biggest mountain was received by the trial defense counsel, who was preparing a Denny motion to introduce evidence of third-party suspects at Mr. Avery's trial. In that Denny motion, subsequently filed by trial defense counsel on January 10th of 2007, Bobby was named as a potential suspect in Ms. Halbach's homicide. According to the trial court, the trial defense counsel had established that Bobby had access and opportunity to have committed the crime, but because no motive evidence was presented, the Denny motion was denied pertaining to Bobby as well as others. According to the state, trial defense counsel had the 7 DVDs in their possession before trial, and all they had to do was look at it. It took Veely only 17 days to do a complete forensic analysis of the Dassey computer. The state's fallacious argument collapses because it fails to address the undisputed fact that it deliberately misled trial defense counsel into thinking that the computer belonged solely to Brendan and the computer content was generated exclusively by Brendan. The state's argument is further weakened by the highly improbable odds of an innocent explanation for both the misidentification of the computer as Brendan's and the misidentification of the 6 DVDs instead of 7 DVDs plus a CD. So basically, in 2 different ways, the state did, in writing, misrepresent these things, and to try to suggest that both of these things could just be an innocent harmless mistake or whatever is How does Luke Berg put it? It strains credulity. I love that saying. It strains credulity. Yeah. So, Mr. Avery's forensic expert Gary Hunt disagrees with paragraph 6 of Detective Michael Veely's affidavit, in which Detective Veely claims that the same or similar forensic tools or techniques are used to examine the 7 DVDs as the CD. Mr. Hunt points out that the 7 DVDs could only be opened with an in-case program, whereas the CD reports could be opened with a standard PDF-capable software, generally included on any computer with web browsing software. Astoundingly, rather than admitting a Brady violation occurred because of the untimely and deceptive disclosure of the 7 DVDs, the state cavalierly responds that it is not responsible for explaining to the defense possible ways to make use of the evidence provided during the discovery process. However, it is the responsibility of the state to make it untimely and deceptive disclosures while suppressing favorable evidence for the defendant. So, yeah, pretty much sums it up. The state was dealing dirty. It was a rigged game. It was just dirty. There's nothing there. I mean, you can't say that there was anything the state was doing in regards to these DVDs and stuff. There's nothing here that you can say that they were being above board or playing fair. This is all rigged. You know, just total rigged game, and it's just sickening. So here's the part where Zellner basically dismantles the claim of the state makes that, you know, well, we turned over part of it, so that's enough, right? So that's kind of their stance. Well, she's about to tell him right here how she disagrees with that, and so here, let's take a look. I'll tell you what, I am liking a lot of the case law that's being cited here. In essence, the state's argument is that partial disclosure immunizes it from any Brady violation claim, even if the disclosure is incomplete and misleading. This argument is a non-starter. In United States v. Bagley, the United States Supreme Court held that an incomplete disclosure of information can constitute a Brady violation, particularly where the disclosure misled or misleads the defense. That sounds exactly like what we got here. Alright, this is going to be the last clip coming up here for this video. But this part's kind of funny because it's referring to the fact that Dean and Jerry had no way of knowing what was on this DVDs or whatever. Even the Fassbender report is labeled as Brendan's computer. So they, they're not, so like I said, they don't know. It has not been made clear to them. It's right at the time where they're at the crunch for Denny. Anyway, so Kathleen now goes into explaining how it's impossible for Dean and Jerry to know that there was something there that they needed to look at when they were in such a, when they were obviously in the final stages of trying to prepare themselves for the Denny hearing and everything. So, and it's like, and nothing is made clear to them. They're not, and she basically goes into the fact that they're not mind readers. The state is taking the position that trial defense counsel, without being provided the CD and being misled about its contents, should have been able to deduce through mind reading of Detective Veely all of the new information described in Exhibit D. The court, in Boss v. Pierce, stated, "In cases like the present one, the question is whether defense counsel had access to Brady material contained in the witness's head. Because mind reading is beyond the abilities of even the most diligent attorney, such material simply cannot be considered available in the same way as a document. This stretches the concept of reasonable diligence too far." The state fails to explain why the CD is not logged into evidence or labeled with a Calumet County inventory number, and why the CD was in the possession of investigator Fassbender for 12 years. There is no credible explanation for this egregious behavior. And I completely agree. Like I said before, dude, the prosecution did not give Dean and Jerry the same advantage that they got. I mean, they got handed everything. They got to see the CD and everything and go through whatever. They had 8 months more than Dean and Jerry had, right? So they had all those things, and then they're just like, separating this all, report here, over here, and then we'll give them the DVDs. Oh, and the CD we'll go have Tom Fassbender just sit on that. We'll have him take that home. He'll use it as a coaster for when he watches TV. Anyway, no, just kidding. But the point is how ridiculous it all is, right? And I think that's what Zellner is really effectively pointing out right here in this particular reply, and it's particularly in the first half of it here. Scanning ahead a bit, I know what it's going to be about. It's going to be about her discussing how this evidence meets all the terms of Brady and all the prongs of Brady and that sort of stuff. So we're going to do that as the part 2. But this is the end of part 1. Like I said, loved watching Zellner picking apart their response. I mean, in a lot of ways, she's just totally making them look like fools, because they are. They've clearly misrepresented many things. The way that they've gone about conducting themselves is completely without morals. And yeah, I don't see, what's that word they use that Luke Berg uses for Len Kaczynski? Yes, indefensible. That's the word that occurs to me. So that's about it for today, folks. Part 1 of Zellner's reply to the state in terms of the Brady violation with the CD. And look forward to part 2 either tomorrow or the next day. We'll see you. If you haven't already, please hit subscribe.